Welcome back to the lecture series. Today's demo session is going to be very interesting because we are going to solve a few questions together. Interesting questions that have come and that have been asked in the Delhi Judicial Services Examination, mains examination of 2023. So before we proceed, let me just take you to the questions and let's try to understand how to attempt this and what is the sub number pattern for these questions that have been asked. Okay, so before we proceed, let me just briefly tell you that these are the questions, two questions that I have specifically picked today from civil paper 2. The pattern of the examination is that there are 10 questions, 10 marker questions asked, which are 4 questions leading into 40 marks. Then we have 2 questions which are of 20 marks, again taking us to 40 marks in total. And the third will be, you have 4 questions of 30 marks, making it 120. So your entire paper will be of 200 marks with these many questions of these many marks each. Now, what is important here is that you get enough of options. So how do we actually prepare? You have to focus on the time because you may have these many questions and this much of marks that are assigned to it, but you do not have unlimited time to attempt this. Okay, so a smart way of working it out will be that you first focus on the questions that starts with the highest number of marks. Those are 30 marks. So I've taken one question of 30 marks and the other question of 10 marks. My intention here is not only to give you a proper answer, but also to explain this particular topic to you. So whatever topics that this particular question is touching on, I will try to cover that as well for you here. So let's try to read the first question, that is question number 13 from the paper, which talks about Copyrights Act. Okay, so this is something, the issue pertains to Copyrights Act, and let's try to understand the facts first. Also, my tip would be that when you're reading the question, do not waste a lot of time, right? You have to be quick, but that does not mean that you miss on the important aspects of it. So let's try to understand the question here. It says Ramesh and Company, this is going to be our plaintiff as well. They claim that they are owners of copyright in various devotional songs. Okay, so first I stop here that they are talking about devotional songs. It has been urged that they have a large repository of copyrighted content comprising of cinematograph, films, sound recording, musical, literary work. So if you have read Copyrights Act ever, you must be knowing that this is the subject matter on which copyright is granted. So when I'm writing my answer, I have already read about it. I'll just in one sentence mention that the subject matter as mentioned under section 13 of the Copyrights Act is something that the particular issue is talking of, right? Then it is the case that in this particular company, that by owning copyright in respect of the said songs and work, they have rights under section 14 of the Copyrights Act. Okay, so taking you to section 14 of the Copyrights Act, if I'll just go to the provision as well. We know that there are certain bundle of rights that are assigned to the party under section 14. Okay, these are the primary rights that have been given, the neighboring rights that we have recognized. All these have been mentioned under section 40. So your question itself is telling you and mentioning about the importance of section 40. Now moving further, it is further stated that in accordance with section 52A of the Copyrights Act, each DVD, CD, VCD produced by this particular company contains a notice bringing it to the notice of the public that the plaintiff has made the sound and video recording. So what is section 52A basically? The object of section 52A is to tell you that, to bring transparency to you, to tell you that who is the actual owner of this particular work, even though that it is being broadcasted or it is reaching to you through other party. Okay, so this is transparency based provision. So they have mentioned about section 52A as well. Now Pawan, now the other party comes into picture. Pawan is carrying on business of providing cable network connections to various subscribers in DEFCOL Delhi. It is the case that this particular plaintiff, that Pawan is having 50,000 connection and Pawan operates various video channels. So Pawan has a broadcasting channel, right? He has these many connections because of whom? Because of the plaintiff. And this is the, when you will be assessing the damages, when you will be talking about the loss that is happening, you understand that he is reaching to these many people through the work of this particular plaintiff, Ramesh and company. Also, Pawan operates various video channels. So he has various video channels by which he is reaching these 50,000 connections. Okay. As per Ramesh and company, Pawan had obtained a license for broadcasting. So first question, that they have not mentioned about the section of license, but we must know about it to mention it in our answer. 30 marker question, you have to mention all these sections and explain them. From Ramesh and company for a period of 3 months. So the license was taken for a period of 3 months for these many connections. So they have mentioned the duration, and they have also in a way mentioned that this will be the particular geographical area where I will be broadcasting your copyrighted material. On expiry of the said license, he never renewed his license. So first thing, that the license was taken, the license has now expired, but you have not renewed your license and continued to use and commercially exploit various works of this particular company. How is he exploiting the work? He is exploiting the work in a commercial manner. Okay, let me just clear all of this so that it's more clear for us to understand. He has commercially continued to exploit the work of the plaintiff despite of renewing the license from the plaintiff. Okay. Now, in these facts, the plaintiff filed a suit for infringement of copyright, seeking an order of permanent injunction to restrain Pawan directly or indirectly from recording, distributing, broadcasting public performance, or communicating to the public, or in any manner exploiting the cinematograph, film, sound recording, etc., owned by the plaintiff. An order of rendition of account is also sought. We will try to find out where this particular thing falls for our clarity, but our question lies here. The question says, in the suit, Ramesh and company, the plaintiff sought an interim injunction. The defense raised was of fair dealing. Please decide the said application. Okay, they are not asking you to decide the suit, they are asking you to decide this particular application, and they have also given you a defense of fair dealing. Now, let's try to understand what is happening here, and then we try to come and give you I'll try to give you the pointers of what all should be there in your answer to make it a perfect, crisp, good answer. Okay. See, when you have clarity of law, you will always write good answer, because you've not just simply read something, you've understood the essence of that particular provision. All these provisions that are coming together. A 30 marker question for very good reasons, because it is covering a lot of sections. So, why is copyright granted? That is my first question to you. And what are the subject matter? So, when we talk about IPR, we say intellectual property rights. Property rights. Why are we calling them property? Because it is your work. If I have written a poem, can I get a copyright on it? Yes. Now, if this is my work, should you be allowed to exploit my work and gain fame out of it? No. That is the reason for which we recognize something as a concept of copyrights, right? Now, this is the primary idea. Now, coming to IPR related to copyrights in this given situation. Why is broadcasting rights recognized? Why have we recognized broadcasting rights? We understand that I am the author of this particular movie, or I'm the author of this particular show. Now, how will I benefit when it reaches to the public, right? How will it reach to the public? Through these agencies. And when I am giving away my right for it to be transmitted to the public at large, benefiting the public as well as the owner of the copyrighted work, there has to be a balance. That is where we bring this concept of royalty that is to be given to the owner. So if I have put my effort, if you have heard of this, there are certain theories, right? And no harm, if you have a 30 marker question, in 1 or 2 sentences you can say, you can mention that recognizing the concept of labor theory, right? Because this is the labor of this particular plaintiff company, that they have a repository. Now, in that situation, how should somebody else be allowed to exploit the intangible or the intellectual property right of the plaintiff. So therefore, we recognize a midway wherein we say that we will allow you certain set of rights, but that will be allowed by way of license. Okay. So we will start with section 13, section 14. Why am I saying section 13? Because you should be very clear. Right now, I am telling you how to understand this topic. You should be clear with section 13 to understand the subject matter of Copyrights Act. You should be clear with section 14 to understand what are the bundle of rights that are so given. So I've prepared a summary of section 14 here that I've written. These are different set of rights. Okay. Reproduction right, issue copy to the public performance, communication, adaptation, and translation. These are certain set of rights that are given under section 14 to the owner. If I am the owner, I can make copies of my work. I have written a poem. I want to make a play. I want to portray or adapt it in a play. Can I do that? Yes. Translation. It is written in Hindi. I want it to be written in Marathi as well as in Kannadika. Can that be done? Yes, that can also be done. So communication to the public. I have written it for myself. Now I want it to be published on a particular platform, right? So all these are set of rights, bundle of rights that are with the owner. And that is what we have recognized and said that as per section 14, the problem says that the plaintiff has these set of rights towards the copyrightable work. Now, after that, we move to section 52A, which talks about you mentioning. So 52A has been followed by the plaintiff. They have themselves, in whatever DVD, CD they are transmitting, they have put a notice with regards to that who is the owner or who is the actual originator of this work, which is now to bring transparency and to give recognition of the rights to the party who is the owner of the copyrightable work. So these are two provisions that are so mentioned in the question. Now, coming to the concept of fair dealing. When I file, the plaintiff files a case of injunction and the defense that was taken was in return of fair dealing. Okay, so we will have to explain that whether this is fair dealing or not, and then we will come and conclude whether you in your opinion feel from the landmark cases, from the provision, whether injunction should be granted or not. Okay, so let's try to understand what is fair dealing. What is fair dealing? Have you ever heard of the term fair dealing or fair use? So what you can do in your answer is that you can talk about both these things. Because this is a 30 marker question, you can very quickly touch on the concept of fair use. Had it been a 10 marker question, I would have asked you to jump directly and to have written only the concept of fair dealing. Now, what is the difference between the two? Let me tell you. This is a concept which prevails in the United States, and this is a concept which is there in UK as well as what has been imported in India. Fair use is more wider in nature as compared to fair dealing, which is much more narrower. Now, why am I calling it narrower? Fair use gives the discretion to the court that when the case comes to them, they will recognize, they will try to find out whether the use or the exploitation that is being done by the other party, the wrongful party, is actually done for a fair use, for a fair reason, or is it not for a fair reason and it should not be allowed. Okay, so they have to assess it on the basis of certain tests. But these tests are not to be followed here when we talk about fair dealing, which is so they're followed in India. We have very clearly mentioned the grounds. Okay, we have mentioned the grounds under section 52 that only in these situations we will categorize the exploitation of work to be fair dealing. So if let's say it is my work, I am Akansha, okay, and X person is exploiting my work, but he is exploiting my work for criticism. He thinks that the poem that I have written is not good and he's criticizing my poem. Okay, or I have sung a song. You want to criticize my song. Or you go and you make a news out of it. This is something that you are actually speaking ahead in front of people to make them aware. The intention is to make them aware. Okay, so either in these two situations, do you think that the person now I can sue that particular person of my exploitation of my copyright work? So that is where we have to understand the concept of section 52 of the Copyrights Act. Okay, So when you're writing your answer, you have to mention, you can in comparison talk about fair use. You can, I'll give you a case also, Folsom versus Marsh. Okay. You can talk about the test that was laid down in this particular case law regarding fair use. And then you can also talk about, after that, you come to the concept of fair dealing, section 52, which is restrictive in nature, which very clearly lays down the ground that if you are using a copyrightable work for review, for criticism, for educational purposes, for research purposes, for journalism purposes, in all these cases, it will be categorized as fair dealing. Okay, so I'll again come to section 52, but right now just a quick recap or a brief of what we have covered. In the given situation, we saw that the parties are dealing with the subject matter of copyright as per section 13. Yes. Then we spoke about section 14. Is that qualified? Does the bundle of rights actually exist with the plaintiff? Yes. Then we move to the question of 52A. Has the plaintiff, the party who's reaching to the court, has he come to the court with clean hands? Has he been equitable in his practice? Yes, he has followed the mandate of section 52A. So far, all good and all in favor of plaintiff. But when the defendant is exploiting, even after the lapse or even after the expiry of the license, the defendant still take the defense and says, I am doing this for fair dealing purpose. So that is where we have to find the conduct of the defendant and assess whether it is correct or not. So I will quickly take you to the Copyrights Act. I have highlighted the relevant portions of the Copyrights Act, which you can later refer also. Okay. So firstly, we have section 14, which talks about meaning of copyright. And this gives you that what all will be included and what will be the rights. So I'll just briefly touch on it. Very lengthy section, but I just gave you a brief of it in my PPT, right? So copyright will be an exclusive right subject to the provision to authorize or do any of the following acts. Any of the following acts in case of literary, dramatic, musical work. So we have just seen in our paper also, in our question also that was asked, they spoke about these set of work only. To reproduce the work, issue copies, perform the work, make cinematograph, translation, adaptation. So the summary that I put in my PPT as well. So these are bundle of rights that are recognized under section 40. Okay. Then we come to section 31D. Now, what is the requirement? How do you get a statutory license to broadcast? So this was recognized by section 31D. If this is not very clear, I'll be reading it out to you. Okay, so you can just listen to me and follow. Any broadcasting organization desirous of communicating to the public. Now, this is the conduct that you are expecting from the defendant if you want to say that yes, this is fair dealing and no injunction should be granted. Look at the conduct of the party as well. So the organization desirous of communicating to public by way of broadcast shall do what? Shall have to apply subject to the provision of this section. Now, important point. The broadcasting organization shall give prior notice in the manner prescribed of its intention to broadcast the work, stating the duration and territorial coverage. Did they follow this? Yes. 3 months I highlighted in the question. I also told you about the territorial coverage that was written, Defense Colony of Delhi. And shall pay to the owner of rights in each work royalties in the manner rate fixed, right? So the whole idea of bringing this concept of license is to benefit the owner. Okay, even though he is giving you the property, intellectual property to you for it to be transmitted, he has to be benefited by providing royalties to him. So this was done, yes, but was this followed later after the expiry of the license? It was not followed. Okay, so you can mention in your answer about section 31D stating that what are the requirements of statutory license and whether that was followed and when did it actually violate the Copyrights Act. Okay, then we also move to section 52. We will see section 52 talks about certain acts not to be infringement of copyright. This is fair dealing, right? We have used the term fair dealing only in our statute, wherein we understand that all these cases, all these situations that are mentioned in my section 52 will not be categorized as infringement of copyright. You are using my work, but still it will not be considered as infringement. And this is the defense that has been taken by the defendant in our case. So a private or personal use, including research. As I told you, the first ground is research for private or personal use, criticism or review of that work. Okay, so if you're criticizing or if you're reviewing any work, that is also fair dealing. The reporting of current events and current affairs, including lecture delivered in public. So if you are reporting any event, also current event, current affairs, that is also absolutely fine. And then this is a lengthy provision, but to take the summary from this, we can understand that fair dealing can be categorized to be in the following cases. Firstly, wherein you are using or you are criticizing the work or you are reviewing the work. Okay, whether it is for educational purposes, if it is for research purposes. Okay, and then we talk about we have taken research, criticizing, and reviewing. Okay, I've written reviewing here itself, or for reviewing purposes, right? All these will be considered as ground of fair dealing under section 52 of the Copyrights Act. Now tell me, now take a moment and go back to the question. Do you think that the defense of fair dealing should be applicable in our given case? Not at all. He is transmitting what? I told you that these are devotional songs and they have a repository of a lot of musical, literary, artistic work. So is it really for these purposes, the purposes of fair dealing? Not at all. So neither for current events or for journalism purposes. So therefore, we can understand that the defense of fair dealing cannot be accepted after reading section 52. You can also, because you'll have to mention case laws, you have to explain these points of fair dealing. So I have mentioned a few cases that I'll tell you also. You must have heard of the DU case, DU photocopy case, right? So these are certain cases that we have to write down when we are discussing about fair dealing, and accordingly your answer will look perfect. Also, because we were talking about the concept of fair use, you can mention this particular case law wherein the tests have been discussed. Okay, so let's try to understand the tests that are there and whether they qualify these grounds or not. So the tests were as follows. Firstly, they said that you have to see the nature of work. Okay, then you have to see the purpose of work. You have to see the effect or the outcome of this particular work, and you have to see that what is the portion of work that has been copied. Now let me give you and explain you with examples what does this mean. Nature of work: is this something that is commercial in nature, or is this something which is which is eventful, which is fanciful, and out of which you are expecting to generate profit? Okay, so commercial or non-commercial. If this is for private research or educational purpose, the thing that we have used in essence in section 52, will it be classified here? This can be first distinction of assessing whether this is fair dealing or not. The second is, what is the purpose? Are you doing this for gaining profit, or are you doing this for utilitarian or for the benefit of large number of people, right? So what is the purpose? Is this for criticizing? If we have to compare this purpose with section 52, is this for criticizing or reviewing or to bring awareness to the public or not? That can be understood in context of purpose of the work. Then effect: is it going to affect the market of the plaintiff? Understand whether he is going to get affected with respect to monetary losses or not, or loss of goodwill or not. So in the given situation wherein the broadcaster is making money, he is generating profit, as mentioned in the question itself, commercial profits have been gained by him. At the cost of whom? At the cost of the actual owner of the copyright. Without paying him any money, even after the lapse of the license, he continues to use. So whether the effect will be there or not, and how much amount. So here comes a very important aspect of de minimis. Okay, we will discuss also. There's a recent case which I feel was the motivating factor for this particular question, so we'll discuss that case law. But the portion is de minimis, wherein we are saying that if the portion is very small or minute in nature, there in that case we can consider that okay, you may get the exception, or you may call it to be a case of fair use. So these are the 4 tests that was laid down in this particular case. This in essence is something that we are following in the section 52 of our Copyrights Act, which you can write in your answer as well. Okay, now this is the case which talks about de minimis, wherein only few 5 words were picked from a particular song, wherein the court said that okay, this should not be classified and considered as a case of exploitation of copyright and rather a case of de minimis. Okay, this de minimis, have you heard of anything in any of the defenses in your law school which basically is very similar to the de minimis rule? So if you have heard of anything, if you can recall any criminal law exception or defense or civil law exception or defense, please write it in the chat box. Okay. Then we also have Shimaru Entertainment. This is a 2022 case wherein we saw some facts that are very similar to the question that has come before us. So my request here would be that whatever you are reading, let's say you are reading Copyrights Act, Arbitration Act, or also because civil part 2 of the exam has very few subjects. It has CPC, it has Limitation Act, Registration Act, Copyrights Act, and then your Arbitration Act. Okay, so very handful of sections. Whatever you are reading, always try to cover the recent updates with respect to that. When I say recent updates, that what are the judgments that have come touching on this particular aspect. So if you attempted this question and if you have actually read this particular judgment, you will find a lot of similarity that exists between the question and this particular case law. So here also there was lapse of license. The party had basically rescinded the contract and the license had ended, but they still continued, this particular party continued to broadcast the entertainment or the copyrighted work of the Shimaru Entertainment Limited. And when it was asked to be stopped, when they asked for injunction, they say that we are doing this for the ground of fair dealing. The court here corrected them, and the court here said that if we see it in the context of section 52, neither of the grounds are fulfilled because these are entertainment purpose, entertainment driven subject matter, and therefore you can't take the exception of fair dealing. So you can mention these cases in your answer to come to a conclusion that okay, this should not be, the permanent injunction should be granted, and secondly, the defense of fair dealing should not be applicable. Now coming to how do you convince and how do you say that injunction should be granted in this particular manner? Okay, so let me just tell you that there are certain remedies which you must know. They're not going to write every section for you there. So you must know that section 55 of our Copyrights Act 1957 basically gives us certain remedies. So I'll just briefly take you to section 55 wherein we can pick that what all remedies have been mentioned. So firstly, it talks about damages that are there. Okay, then it talks about injunction. Then it also talks about the accounts, rendition of accounts that can be taken. See, injunction, by way of injunction, damages, accounts, and otherwise. So you can also take damages for conversion. If you have converted or if you have changed the copyrightable work from one to another, you can also take damages for conversion. So these are remedies, civil remedies for infringement of copyright that are mentioned. So when you're writing your answer, you have read section 55, why not mention that as well? That section 55 of the Copyrights Act allows that there can be temporary injunction or permanent injunction that can be sought in this particular given case. Now, what are the requirements of injunction? Again, you have to decide that there is a prima facie case, right? So in prima facie case, you will have to acknowledge and you will have to tell that there is a valid legal right that exists with the plaintiff. Is there a valid legal right? We just did an entire discussion on section 40. Then we spoke about that there is going to be balance of convenience, right? So you have to find out and you have to say that how this entire injunction, if not granted, will be inconvenient for the plaintiff because there is exploitation that will continuously happen and damages to be assessed is going to be a little tricky to be decided by the court later. And also you have to discuss about the irreparable damage. So this was also this was also decided in this particular case of 2022, wherein the court said that all these categories are fulfilled, and therefore the requirement of granting temporary injunction arises in the given set of facts. So this can be your answer. All these important points can be there, and then you can conclude by all these points that I have written, that the license is obtained for valuable consideration. Whenever license is given, it is for a valuable consideration, and because he is making commercial profit out of it. Also, he is exploiting substantial part of the copyrightable work. It is not minimal. Then both qualitative and quantitative aspect is to be seen. As I continuously highlighted, that these many connections have been broadcasted by this particular person, and he has various video channels, right? So you have to mention both quality as well as the quantitative aspect also. You can justify your answer. And then the nature of activity, whether same for both the parties. Yes, the broadcasting agency he's broadcasting the same set of things, same set of videos that are in the repository of the plaintiff, and the purpose of use is commercial and entertainment based. So on these grounds, you can say that that the injunction should be granted, and the defense of fair dealing does not materialize here. Okay. So we took good 31 minutes to understand this particular first case law. First question that has been asked regarding Copyrights Act. I have given you key points which you must mention in your answer. The sections, the case laws, landmark case laws that you must mention in your answer. And if you attempt your, a question based on the same set of facts or similar set of facts, always keep covering all the legal updates that are happening related to that particular topic. Okay, then I quickly move to my next question. Very interesting 10 marker question, but to understand this 10 marker question is going to take us good amount of time. So the question asked is, can a non-signatory under an arbitration agreement be impleaded as a party to the arbitration proceeding? Please elaborate, giving details of applicable statutory provision and latest case law. Latest case law and statutory provisions. So let's try to understand what is the requirement of this question. They are talking about arbitration agreement wherein there is a party which is non-signatory. So if you are aware, or if you're not aware, I'll just explain it to you, that arbitration agreement has to be in writing. Am I saying that, or is that something that is written in the law? So firstly, I said arbitration agreement has to be in writing. It is written in the law. I have no authority to say so. So this is under section 7. Okay, we will discuss. Then it must also be signed. So if the parties are there, they can also sign this particular arbitration agreement. A party who has not signed will be called as non-signatory. Okay. So the non-signatory to this particular arbitration agreement, how can they be impleaded as a party for the arbitration proceeding? That is the first thing that we have to understand. And we have to substantiate our answer with the statutory provision and case laws. Okay, so this is how we begin. So as I just said, that we have to go to Arbitration Act to find out what is an arbitration agreement, what is the definition of parties, because they are asking you to provide statutory provision also. So we have certain provisions that we must refer to. Let's go to section 2 clause H, and let's also understand section 7 of the Arbitration Act. So for this, we will go to Arbitration Act. So this is section 2 of the Arbitration Act, and I am moving to the clause 7, that is party. Party means a party to an arbitration agreement. They do not give you a lot of details in this particular provision. They say party means a party to an arbitration agreement. Now you don't get an understanding as to whether they are talking about somebody who has signed the agreement or who has not signed the agreement. That is why the discussion happened, and that is where the entire confusion occurred. So we have section 7 to substantiate and for us to understand. That arbitration agreement means an agreement by the parties to submit themselves to all or certain dispute which has a reason or which may arise between them for a defined legal relationship, contractual or not. Now, I quickly spoke about this because this is not where we have to stop. We have to stop at this particular provision. Okay. So subsection 3 is that the arbitration agreement shall be in writing. As I said, it is mentioned in section 7. And subsection 4 says that it will be considered that it is in writing if it is contained in a document signed by the parties. So if it is signed by the parties, you are a signatory to the arbitration agreement, and therefore you can be impleaded in the arbitration proceedings. But now comes the catch. This is the catch. So I am highlighting section 7(4)(b). Okay. This is an exchange of letters. An arbitration agreement is in writing if it is contained in an exchange of letter, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provides a record of the agreement. Now, does it specifically talk about telegram or telecommunication between the parties? So that is how we construed and we brought the scope of impleading even a non-signatory to the arbitration proceeding. Okay. So you can start with your first. If you are writing your answer, firstly, you must tell that how have we defined the term parties under the Arbitration and Conciliation Act. Okay. Then you speak about that what is an arbitration agreement and whether this arbitration agreement has to be signed by all parties, or is there any scope of bringing any non-signatory also to the arbitration proceeding. Now, we also try to find out that what have been the updates by which we have come to this conclusion. The question has been asked because these are recent updates which were introduced by case law. We did not bring any amendment in the Arbitration Act by saying that a signatory or a non-signatory. So this is something which was introduced by virtue of case laws, which you must know. So I will tell you now, I'll take you to the case laws. This is the first case law that we'll be talking about. I will refer this as chloro controls. Okay. Then we will talk about the next case law, that is Cox and Kings Limited. And then the third one will be the very recent case law of Ajay Madhusudan Patel. Okay. So these are three. When I am going in chronology, you have to see that the years also go likewise. One is 2012, then 2023, and then 2024, adding, subtracting something from the judgments. Okay. So let's try to understand what are we discussing. And also we have to understand that why non-signatories must be impleaded, why the scope of non-signatory to be impleaded in arbitration proceeding has come up. So if you are a party, you may not be the one who has signed it. Okay. Signing is something which is essential. The recent judgment also says that it gives a very clear idea to us that you intended to come for arbitration proceedings. But at the same time, even though if you have not signed, but your intention was there, will it be important for us to include you as a party? Yes, to bring efficiency. Then I have just mentioned pointers here which must be there in your answer, that India is a country where we have promoter driven family businesses. So we have this case also wherein you will find that the members of the family are only there, who are part of different organization and then different companies, and then they are contracting with each other. So in that situation, and in case where there are large scale infrastructure projects, will it be essential that there can be a third party who is helping in the performance, okay, or who is helping in the execution of the entire agreement that exists between the two parties? Will that party be also essential, and should that party be also impleaded in the arbitration proceeding? Even though when they have not signed it, it will be important, because we want efficient arbitral process. We want a judgment, we want an arbitral award which has come following the principle of good administration and justice. So to bring efficiency for effective dispute redressal. Later, we do not want an award to be challenged on this ground, and that is why it becomes important for you to discuss that why non-signatory should be a party. Okay, so this is how you can start your answer. You talk about what is a party, you talk about how party has been defined and where is the scope of extending the provision, existing provision, to include a non-signatory, and then you talk about why is this important for us. Now, let me remind you that the question is a 10 marker question. I am teaching you because I'm explaining the topic to you. I may take 40 minutes, but you will not have 40 minutes to write an answer on this. So you have to briefly and quickly pick up the important point and frame your sentences in that manner. Okay. So do not waste your time over explaining something. Stick to the important points, summary, and then accordingly frame your answer. Okay. Now, what has happened in the first case? Now, this is something wherein section 8 was quoted, and I will tell you why section 8 and how we have changed the explanation. But chloro controls is the first case starting from 2012 where we recognize and acknowledge that yes, even though you're a non-signatory, if you are part of the same transaction, if you are performing or if you are in any way contributing to the transaction, you can be impleaded and you can be included in the arbitral proceeding. So this we have already covered. The court here said that GOC doctrine. I'll come to GOC doctrine. Okay, I'll talk about the doctrines as well, but only the important point. The court here said that the doctrine finds its root that claiming through under party section 8. Okay, what is this? I'll just explain it to you. Now we have to go to section 8 for us to understand this. And when you're writing your answer, okay, I'll just tell you, it will give very good impact, and that you have a very good understanding on this particular aspect, that you definitely mention about section 8 and 11. Okay, why is this important? Because time and again in all the judgments it has been mentioned that this is something, whether non-signatory is a party who should be impleaded, this is something that is to be decided by the tribunal. The court has to decide what, that whether an arbitration agreement exists or not, and they refer the case to the AT then, and the AT has to then decide on the question of whether the non-signatory party is a party who should be impleaded here or not. So this will give clarity. Time and again in all these judgments, this has been an important question, and you must refer to this as well. Now, in the first case of chloro controls, section 8 was, highlighted, and section 8 was taken as a recourse, as a base to say that yes, non-signatory are also parties. Now, how did they interpret it? Let me tell you. This is not what continues, okay? But you must mention very briefly. The starting from 2012 in the judgment of this, we have the interpretation of section 8 which says this, and then in the next judgment you say that, but later in 2023 we have clarified that this has changed, this position has changed. Now also let me tell you, it's not just 2023. After 2012 there were many cases wherein we tried to clarify that section 8 interpretation is not rightly done in chloro controls case. They said how non-signatory has a place here under section 8. A judicial authority before which an action is brought in a matter in which it is subject to an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies. Any person claiming through or under him, not just the party to the arbitration agreement. They interpreted that the non-signatory can fall in this ground, can fall in this category of any person claiming through or under him, which was later clarified as to be a wrong disposition and something which is going to widen the scope of section 8 to a very larger extent, which we do not want. Okay, so Cox is the chloro control is the first case wherein we have spoken about section 8, and this is overbroad and expansive interpretation which created interpretational issues, so we do not continue with that. The other factors which were laid down in this particular case itself were that if we want a non-signatory, we have to find out the existence of a direct relationship with a signatory. Now, what is the direct relationship? I'll tell you. commonality of the subject matter, I'll tell you this also with the recent case law, and the existence of composite transaction. Okay, so these are certain grounds. They said that if you want a non-signatory, just see whether the non-signatory had a direct relationship with the signatory or not, whether the subject matter of the transaction between the non-signatory and the signatory is common or not. So these are the grounds that have been told. Now, what is this GOC doctrine which you have highlighted but not spoken of, ma'am? So GOC doctrine is basically an important essential doctrine that we are going to cover, and which we cover even till now, wherein we talk about the group of companies. Okay, if you are part of a group of company wherein the entity that is a signatory versus the entity which is not a signatory, but both are working under the same group, and if they are also, either there is a direct relationship, or they share the subject matter, or they contribute in the performance, in all these grounds we will assess and decide whether, even though you are a non-signatory, you can be included or not. Okay, so this is from the first case of chloro controls. Then we come to Cox and Kings. Okay, I'll be explaining this part again because it will come later as well. Now, what happened in this particular case, if I have to draw and explain it to you, I'll just very quickly draw and tell you. So there is first company, that is the Cox company, versus the other company, that is the SAP. Okay. Now, they had a contract with them with respect to a particular software, some ERP software, wherein they promised that, okay, the software will work in this particular manner. When the issues arose, the parent company, okay, SAP SE, the parent company, German based company, comes into picture and they start helping them. Now, what has happened? The parent company has come into picture and they are helping them fix the issue for a very long period of time. They also overtake and they also try to see that how we can, with the experts and whosoever were there in the panel, they try to help this particular company. Now, there are a lot of other facts also which are not important for our present discussion. Here, if this particular party has to go for arbitration proceeding, can they take respondent 2 also? This is respondent 2, this is respondent 1. Can they implead respondent 2 also to the arbitration proceeding or not, is the discussion that had come before the court. Okay, so this is the simplest way that I could tell you the facts. Now let's try to understand in the given set of facts what will happen. So the court in this particular case highlighted two set of parts. They said that whenever you have signatory, non-signatory, and these parties in front of you, there will be two parts in front of you, and you must mention this in your answer also. Okay, one is the consent-based part, the other is non-consensual. Non-consensual basically means, because it was so used in the judgment, they basically mean something which is expressed. Consent based is expressly mentioned, and something which is impliedly mentioned. Okay, so you will have two parts in front of you. One where the party has given consent and they have expressly mentioned it. So how do they expressly mention? If you have a contract of agency, or if there is a position where uplifting of corporate weal has to happen. Now, in all these cases, or if there is, a contract where equity suggests us that you have to see the working between the non-signatory and the signatory. In that particular situation, this will be considered as non-consensual path, wherein you will have to extrapolate the arbitration agreement to the non-signatory. This will arise only and only in cases of these non-signatories. Okay, only on these example, if there is a contract of assignment, if there is a contract of agency, equitable estoppel, alter ego, or veil piercing. In all these cases, you have non-consensual path. That is the first path that can be taken. I will try to find out whether the contract of agency exists between them or not, with the non-signatory exists or not, whether equitable estoppel will bind this particular party for the representation they has made. Alter ego or vealing or veil piercing, how does this work? If, let's say, the signatory was merely working as a shell or alter ego of the non-signatory. These are all doctrines and theories if you have read companies law. So in the recent judgment also that we'll talk about, Madhusudan, our ex-CJI had clearly said that we acknowledge that the Companies Act considers these subsidiary and the parent company to be two entities. But if a situation like this exists wherein the subsidiary is working as a shell, in that particular case we will have to pierce the corporate wheel and we will have to find out whether the non-signatory should also be liable to the arbitration agreement or not. Okay, and the last one is the group of companies doctrine, where there is implied consent. Okay, so implied consent has to be seen where you do not find existence of an agency agreement or all these set of agreements. So this is the first assessment that has been done in this particular landmark case. Now, moving ahead, the court also referred to section 8 and clarified that, how does it work? Firstly, we do not take the help of section 8 in construing that non-signatory is part of this particular transaction, okay, the arbitral proceeding. Secondly, we have to refer to what are section 2 clause H and section 7 4B, by which we consider and by which we can conclude that a non-signatory can also be a part of arbitral proceeding. And who will be the one deciding this? Not the court, rather it can be in the domain of the AT. As I told you, it's in one or two sentences, try to fit in section 8 and 11's reference here, by which you can give clarity to the reader that you understand that this is a question that is to be decided by the AT at the later stage. Okay, not at the stage of section 8 itself. Okay. Now, the factual threshold. Now, how do we say that the non-signatory can be decided? So I've written that if the non-signatory had a positive, direct, substantial involvement in the negotiation, performance, and termination of the contract. So the Madhusudan case, you will find their presence in the negotiation as well as the stage of performance. That is how these part of the judgments become very important. So when you're writing your answer, if it is a long answer or 30 marker answer, you can mention about the facts, and then you can mention about these essentials also, wherein the requirements of invoking or the requirements wherein you fit actually a non-signatory can be invoked. Okay, and the mere incidental involvement will be insufficient to bind a non-signatory. See, ultimately it is the party discretion, right? The parties have decided and then they have come up with an arbitration agreement. So can you bind a non-signatory who did not have the intention to be bound by it? No. So that is why we say that merely incidental involvement will not convince the court. It has to be seen in context of the highlighted portion over the screen: negotiation, performance, termination of the contract. Okay. Then we move to the last case, or related to the most recent case related to this particular aspect, wherein there were again three parties. Okay, there were one is AMP, the other there are, and both these particular entities were owned by the people of the same family. Okay, so family X, member Y, and member Z own these particular company AMP and JRS. Now, what happened here is that they had a particular agreement between them. That was the family arrangement agreement. Okay. And this entire agreement, the negotiation was done in light of a third party, the non-signatory party again. Okay. The negotiation of the agreement was done in light of the third party. He continuously participated in the negotiation while making of the agreement, or as well as for the execution, because there was shares that had to be bought from the entity of this particular third party. There was continuous involvement of the third party in the transaction. Therefore, the court held that here, even though you are a non-signatory, it becomes important for us to implead you as well, for you also to be impleaded in the given situation, for the arbitral award to be for it to be fine, valid, and for it to be not later challenged on unimportant grounds. Okay, so this is the important aspect that I've highlighted: the mutual intention of the parties, the relationship of signatory with signatory, commonality of the subject matter was also same, composite nature of the transaction, performance. All these will signify and show us the intention even of the non-signatory to be bound by the arbitration agreement. So these are case laws that you must mention in your answer, along with the statutory provision that we read in the beginning, for you to substantiate, for you to convince that yes, I stand with the point that a non-signatory should be impleaded. Okay. All right. merely action or conduct could be an indicator, because see, here you do not have a sign. So the court says that how do we find it out that when there is no sign? So it can be seen on the basis of the action and conduct of the parties. Then these are four other essential that you can take a screenshot of also. An arbitration agreement arises out of a legal relationship existing between parties. Then I have highlighted that either of the parties must be intending or consenting to be bound by the arbitration agreement. That is the essence and that is the idea behind having an arbitration agreement. You must have intended either, or you must have actually consented to the arbitration agreement. And merely because there is a written arbitration agreement which does not talk about the non-signatory party, it does not exclude the possibility of having a binding effect on the non-signatory party as well. Okay. This is also one of the cases wherein we have certain grounds that were laid down. We have to see the mutual intention, commonality, all similar factors only. But I would suggest you to at least remember the top three cases that I discussed with you, because these are landmark judgments that have recently come and can be, a question in your future exams as well. So with this, I will be concluding, and my take here would be for me to tell you that when you're reading any particular, see, the recent judgment of 2024 is also based on the old premise or the previous judgment of 2023. So whenever you are reading anything, if let's say today I'm reading about section 8 or section 11 of the Arbitration Act, or um, or I'm reading about section 16 of the Arbitration Act, whatever it may be, first you have to thoroughly read what is there in the provision. Then you read the relevant judgment, you read it from your textbook, and then after that you come and try to cover all the recent judgments related to the same. I am again and again emphasizing on it because I know if you are planning or if you're targeting on Delhi judiciary examination, they will always ask you questions which can be based on the recent updates. Okay, so always keep yourself updated, and you know where to update yourself from. You can join Livelaw, or you can join Livelaw Academy for this sort of a discussion or this sort of a class interaction that we will be doing in our lectures. Also, let me just tell you, because we have paucity of time on YouTube, I intend to give you answers very quickly. When we will be discussing the same topic in our classes during our lectures, definitely I will take each case law and explain it thoroughly to you, followed by your doubt session. Okay, now if you were with me up till now, and if you have attended the class, I have something to give you as a return gift. Okay, there are certain questions from the preliminary question as well. Okay, so the title of the today's lecture, or the title of the YouTube lecture series for today, talks about the mains answer. But just as a brownie point, I have certain questions from the preliminary examination as well that I will try to solve with you, help you understand how to attempt these questions and where do you find the answer for these questions. Okay, so you have your answer keys, you can see A, B, C, D, but what is the reasoning behind that A, B, C, D is something that I'm going to tell you. So I've picked 4 questions from the Arbitration Act itself. Let's begin very quickly. The first question is, a person X is appointed as a conciliator to attempt conciliation of dispute between party A and B. So there are two parties, they appointed X person to be the conciliator, but the conciliation proceedings terminated. And after that, the party are now seeking to adjudicate their dispute through arbitration. They want now to go for arbitration. Which one of the following is a possible scenario? Now you have to find out which one of the 4 options that you have is a possible scenario that can arise in this particular given set of facts. X is appointed as a nominee arbitrator of party A in the arbitration proceeding. So if you have referred to section 11, if you have seen 5th and the 7th schedule of the Arbitration Act, you will understand that if he was already a conciliator and he is now to be a nominee arbitrator of one party, that may actually bring the scope of him being impartial, right? So not the best option that we have. X is appointed as a sole arbitrator through a judicial order. This can be done under section 11, but let's read the other options also. X appears as a witness in the arbitration proceedings between A and B despite no consent of the parties. And the last one, X is appointed as a sole arbitrator with the consent of party A and B. So if you have this option, I am sure you know which one to take and which one to find it to be correct. It should be the last one, because Party autonomy. First thing, you let the parties decide. You can also refer to section 11 clause 2, wherein you will find out that if the parties have to decide, the parties have to see the pick the arbitrator, and only if they fail, then we come to this particular ground. So this will be our answer for the first question. Then an arbitral tribunal shall have a lien on the arbitral award only for administration fee. So this is very specific to a particular provision. You can refer to section 39 clause 1. You will find the same thing there. That subsection 1 says have a lien on the arbitral award for any unpaid cost of the arbitration. So section specific question also has been asked. Then the next question is, under section 11 of the Arbitration Act, the arbitrator has to be appointed. Now, this is not something which is directly written, but it is so written under the Arbitration Act itself, wherein we say that 30 days from the receipt of the request for appointment of arbitrator from the other party, not 30 days from the arbitration agreement or arising of dispute. One party will put a request for appointment of the arbitrator, and then within 30 days it has to be so done. Again, the answer lies in section 11 itself. Now, the next question is, which of the following is an incorrect statement? So we actually refer to a part of this particular question during our discussion today. An arbitral award is a contract. An arbitral award must be in writing and must be signed. An arbitral award includes an interim award. So you can refer to section 2 clause C, and if we already refer to section 7, okay, this is arbitral award must be in writing and it must be signed. So let me take you to this particular provision also, wherein we can see section 2C as well as we can see section 31 to understand what should be the forms and content of the arbitral proceeding, arbitral award. So section 2 clause C very clearly says arbitral award includes an interim award. That is the last option given to us. So we know that 3 is correct, and we have to find out the incorrect statement. Then we very quickly go to section 31 that talks about the form and content of the arbitral award. The arbitral award has to be in writing and it has to be signed by the members of the arbitral tribunal. Is that is what is written here? Yes. Arbitral award must be in writing and must be signed. So what is the incorrect statement? This is the incorrect statement. So with this, we are done with today's lecture, today's discussion. We will have a follow-up series of other questions that I'll be taking up, which we will have very soon. You can attend and you can join us for that as well. And thank you so much for your attentive listening and for your patience listening.